Any other questions or things for Jay? If not, I'm going to turn it over to Chief Clements. Chief?
So, Mr. Chairman, so first off, as always, General Nerona explained it very well on the legal considerations in the legal strategy on Jimmy Vincent's question. That is always the case where that is the predominant charge when you have both criminal and a LEOBoR situation going on. So thank you, General, on that answer, because it's always a consideration and a greater consideration when there is a complicated case or a greater case of discipline. So what I'll say is, up front, Jake, you did an outstanding job. You can see by the questions for people on the outside to consider looking at this data, it does become confusing. And I thought you did a great job both collecting the data with the questions you've asked and as well as presenting. So, and just to put this into some context, and Mike Avora's question speaks right to it, is, so two things I think are abundantly clear. Number one is the major time delays that we've seen from the survey put out to the police chiefs and everyone involved are when there are criminal charges. So when there is a major case of discipline that have both a criminal charge and a potential LEOBoR hearings, that's where the delay comes in. At no fault of anyone. I mean, that's part of the process. And I think, as the General explains, certainly the criminal portion of it is the more predominant consideration that we all should consider where we want to impose discipline. So that's number one that's been crystal clear in the survey to the chiefs. And number two, I think what is clear is LEOBoR is used very sparingly. You look at the data. I mean, 4 times in the last 5 years. I've been the chief in Providence for 9 years. In 9 years, twice we've used LEOBoR. That is not remotely to suggest that we do not impose discipline. In fact, we impose discipline oftentimes, a lot of discipline. And there are different layers of discipline. As Chief Rathbun from Warwick identifies, there are different silos of discipline or questions that come in on police action. One is citizen complaint driven and another is internal. And we look at both, we look at all. So there's different avenues of complaints, number one, and there's also different layers of discipline. So we have far more than the numbers presented to this panel, in that, you know, much of the discipline, if you would consider it discipline that we impose, is also used as a training mechanism. So we have layers of discipline that can be handled at the sergeant's level, at the lieutenant level, at the district command level, before it reaches the level of the Office of Professional Responsibility and the Chief of Police, which is an arm in every department of the Chief of Police. So the Internal Affairs and or OPR answers directly to the Chief of Police. So many of our cases of discipline go to that arena. They're in that forum. However, many other cases that some on the outside may question, well, is that discipline? Yes, it is. But it hasn't reached the level of the Internal Affairs Office. So it may be something relatively minor where there was a verbal type warning and a training type scenario issued to that officer to become better in providing a more professional service in the public. So I just want to put that in some sort of context. So when you go back and look at the year, and this is directed towards Mike Avora's question. So the way I read the question, you look at the year 2015 in box A and box E. So as an example, in 2015, Providence Police imposed 47 cases of discipline. Question B is the annual number of discipline cases during that year that did not require a LEOBoR hearing. Well, it was 46. So 47 cases of discipline, 46 were imposed, one went to a hearing. We went to a hearing, and just to put it in its context, it went through a lengthy strategy session. We go to a full-blown hearing. It cost the department about $30,000 on our end to conduct that hearing. And then we go through the LEOBoR hearing. We make our case. There's a guilty finding. Now the case is appealed to the Rhode Island Superior Court. It costs the department in the city $12,000 to run through that appeal. So our number in year 2015 for the total number you have in section I for cost, 42,000 of that is for the one Providence police case that went to a Bill of Rights hearing. Now again, you had 46 cases that year that did not require a Bill of Rights hearing. And I would put into the discussion that each of those years, so then you go to 2017, my answer to question A was there were 39 cases of discipline. Question B, how many of those did not require a Bill of Rights hearing? 39. So 39 were imposed without the imposition of LEOBoR. Go ahead, Jake.
Chief, just as a to return back to maybe what Mr. LEOBoR was getting at, but that's not necessarily to say that an officer were some of those disciplines handed out of those that 39, if I recall correctly. Could the officer have gone to a hearing if he wanted to?
Yes.
Okay, I just wanted to. So it's an amalgamation really of two things. Maybe some discipline that didn't warrant a hearing, and two, also officers foregoing their right to a hearing.
And that's correct. And that brings me to a point I was going to make in a short time, but I'll make it now because it's apt to both your point and Mike's question, is that, look, when there are cases of discipline, there is strategy used by the attorneys and the chiefs as to what direction they're going to take. And there are strategies taken by attorneys who represent the officer. So as well, and to the point of imposing discipline, if in the case of the Providence Police, and I'm sure every other department, in the Providence Police, in the last 9 years, there have been 27 times where discipline has been imposed in the form of termination or resignation. Each one of those 27 potentially could have been a Bill of Rights hearing. In each one of those 27, the officer was removed prior to a Bill of Rights LEOBoR hearing. So my point is that it continues to be a great tool for chiefs of police. And I think we're talking about some things on this commission that will improve upon the professional policing services that the departments around the state and the present component of chiefs of police, which in my opinion, I've been around a long time, the present component of chiefs of police in this state is bar none the most professional in the country. We serve on panels regionally, nationally, and I think everyone has that vision, that commitment. They want to present and provide the most professional police service we can for our communities. So as it relates to this LEOBoR discussion, there are many times where LEOBoR has been used. Every time it's used as a tool. So, and it's a tool that is used by the evidence sparingly. Four times in the last 5 years. I've been the chief 9 years, twice. And in all those cases of discipline, you look at the 27 where people have been removed from service, forced to resign or terminated because they didn't want to go to a Bill of Rights hearing, because they knew the position of the department would be removal, would be termination. And they didn't want to take, if you will, that roll of the dice in that it costs, you go back to my point on question I, good job, Jake, with the question, it cost the city $42,000 to present that case. What does it cost the individual to take that shot of going to a Bill of Rights hearing? So it's a calculated risk on all involved, and it's similar to what Attorney General Peter Nerona does with every cases. you know, I don't know the percentage, but the vast majority, I could throw a number out there. I think I know a close number. The vast majority of cases that travel through the system are pled out. They're adjudicated out because of that calculated risk. So go ahead, Jake.
No, before we continue, I just want to make sure I get my question in. I guess a quick, listening to Mr. LEOBoR and everyone really, a key question is how can we increase the public trust in the process when discipline is being handed out, but there may not be transparency surrounding it. So, if we're talking about building the trust and the transparency is a key piece, and only 4 are progressed to a hearing panels, but there was a lot of discipline, and the public should have some right to know why and if there are repeat offenders. So I wanted to get that out, and so that's a question that came to mind as I was listening to the discussion going on. Jake, go ahead, and then we'll go to Mr. Vincent.
I was just going to point out that Mr. Vincent had a question, had his hand up.
Yeah, I just had 2 quick questions. Chief, how you doing? Jim Vincent, NAACP. Chief, you just made a statement that you've never seen the Chiefs of Rhode Island more professional in your career. Now, Anastasia Williams, Rep. Williams has a bill that would increase the unpaid suspension from 2 to 30. In your professional opinion, do you think any Chiefs of Rhode Island would abuse that power if they had up to 30 days to impose discipline? Would any Chiefs abuse that power?
The present component, no. However,
Okay, that's one. Okay, thank you. And the second one is, if you had the power to suspend somebody up to 30 days as opposed to 2 days, do you think that you would have even had that one LEOBoR hearing, costing the city $42,000, even that one, if you had 30 days over somebody's head, if you had that tool before, previous to now?
I'm sorry, say that again, Jimmy.
No, I'm saying if you had that tool of 30 days as opposed to 2 days, I'm thinking you wouldn't even have had that one LEOBoR hearing, and you would have saved the city $42,000. Is that faulty logic or what?
Personally, in my opinion, yes, in that, we've imposed a lot of discipline in the form of 10 days, 30 days, 3 months, 6 months, a year, prior to going to a Bill of Rights hearing with the present language codified in LEOBoR that stipulates only up to the possibility of 2 days. So I think this commission is going down the right track with the discussion of increasing the number of days. But to your answer on that, my answer would be no. I mean, it hasn't worked that way for me personally. That may be another question. I believe it was a question asked by Jake, and that's why we came up with the number in the survey that was somewhere between 5 and 10 or 10 and 15 through all the 37 chiefs of police who responded.
And my feeling is that if it was 30, as in Rep. Williams's bill, you would never have any LEOBoR hearings.
No, that wouldn't have been because I only had 2 in my 9 years. If I had 30 on both of those, they still would have gone to hearing.
Okay, thank you.
And on all the other ones, I've gotten far more than 2 days. Never mind the 27 terminations or forced to resign. And you think about that, in 9 years, that's 3 officers per year. Show me another institution through their discipline matrix internally where they're removing that number from their workforce. I mean, those are real numbers.
Thank you.